So coming back to our discussion yesterday, we had stopped at Article 21 of the Constitution. Basically till now what we have discussed under Article 21 is why Article 21 of the Constitution is considered to be fundamental of all fundamental rights. Why is it that B.R. Ambedkar calls it as fundamental of fundamental rights? We have seen that if you look at Article 21 of the Constitution and which guarantees us right to life and personal liberty, if we do not have a guarantee of right to life and personal liberty, all other fundamental rights are meaningless. All other fundamental rights are meaningless. On the other hand, if we only have our fundamental right to life and personal liberty, and if it is liberally interpreted, it would subsume all other fundamental rights within itself, and hence Article 21 of the Constitution is considered to be fundamental of all fundamental rights. If we go back to our previous discussion, in that particular discussion we had also seen that how over a period of time Article 21 of the Constitution has been interpreted by the Supreme Court, and how in the last 70 odd years it has undergone a liberal interpretation, and the scope and ambit of Article 21 of the Constitution has been expanded. Today it does not just mean right to life, it means right to a dignified life, and right to a dignified life includes various inferred rights within it. Very recently the Supreme Court also declared, interpreting Article 21 as privacy, the right to privacy being a part of our fundamental rights. Other rights such as right to livelihood, right to health, right to right against denial of wages, right against arbitrary punishment, and there are so many other rights that have been inferred by the Supreme Court as a part of right to life and personal liberty. However, this was not the case always, and if we go back to the year 1950, in the A.K. Gopalan versus the State of Madras case, the Supreme Court took a very parochial interpretation of Article 21, wherein the Supreme Court said right to life and personal liberty only includes right to protection of an individual's bodily parts. It does not include liberty as guaranteed to us under Article 19 of the Constitution. The Supreme Court also said that procedure established by law should be read as procedure established by law, and principles of natural justice was not incorporated as a part of Article 21 of the Constitution. In the Menka Gandhi case, the 1978 Menka Gandhi versus the Union of India case, the Supreme Court overruled its earlier decision and expanded the scope of Article 21, wherein the Supreme Court went ahead and said that Article 21 of the Constitution, it also incorporates the principle of natural justice. Procedures established by law should be read as due process of law. Personal liberty and liberty, there is no difference between personal liberty and liberty, and detention of an individual should not only satisfy Article 21, but it should also satisfy Article 19 of the Constitution. Thereby, in the Menka Gandhi case, or since the Menka Gandhi case, the Supreme Court took a very wider interpretation of the idea of what is meant by this idea of right to life and personal liberty. And since 1978 itself, number of times there has been number of cases in which Supreme Court has expanded the scope of Article 21. See, actually Menka Gandhi case had a background. It was post-emergency period, and post-emergency period the Janata Party, once the Janata Party came to power, the Congress Party lost elections, not just the Congress Party, even Indira Gandhi lost her traditional seat, and post the coming up of Janata Party, the Janata Party also started they also took up certain measures which may not be considered as completely democratic. It was arbitrary, like they personally targeted no, the Gandhis, including Menka Gandhi. Menka Gandhi, who was a very, no, she was a very vocal critic and defendant of Indira Gandhi at that particular period. So she was detained. When she was detained under, by the executive in their detention, because she was also a very, she used to write columns in various newspapers, etc. She was a very, she used to do that. So she was stopped from doing that. Because she was under detention, she was told that this is not something that you can do, and only on this very ground it was challenged in the Supreme Court, and the Supreme Court took a very different interpretation of what was meant by Article 21, wherein it said not only Article 21 or detention of an individual should not only satisfy Article 21, but it should also satisfy Article 19, which means right to freedom of speech and expression. It is not just available to an individual who is free, but also an individual who is under detention, thereby providing such rights to individuals. ठीक है, ये background था basically. Now, coming to the last part of our discussion, we have seen basically three things: procedure established by law, due process of law, and principles of natural justice. So what is meant by procedure established by law, what is meant by due process of law, and what is meant by principles of natural justice is what we have to discuss here. Let's start with procedure established by law. Let's start with the meaning of this idea, procedure established by law. What is meant by procedure established by law, and how it is different from due process of law. Now, what is the difference? Why is it that the Supreme Court reads procedure established by law under Article 21 as due process of law, when it says that there is no difference between procedure established by law and due process of law? What does Supreme Court mean by this? Now, what is meant by procedure established by law? If you see Article 21 of the Constitution, what does it say? It says that every individual, every citizen has the right to life, or the state shall not deny any individual his right to life and personal liberty except for a procedure established by law. That means an individual can be deprived of his life or liberty, but such deprivation that should happen, that means an individual being denied of his liberty, personal liberty, or an individual being denied of his right to life, it should be according to a procedure that has been established by law. So what is meant by procedure established by law? Suppose an individual has been detained. Suppose an individual has been detained by the executive. So if the individual appeals to the court as to why or whether the detention is legal or not, then the court is likely to look into a few things. First, the court is likely to see that there should be a law, or there shall be a law authorizing such a detention, because we have already seen Article 20 of the Constitution, and Article 20 of the Constitution says what? Article 20 of the Constitution says I can be punished only if I have breached a law that is enforced at that particular period. So when I am being detained, in that case, if I appeal against my detention, then the court is going to look at what? When the court is judging or looking at the legality of my detention, the court is first of all, the first thing that the court will look into is whether the law whether my detention has been under a law. If my detention is under a law, fine. If my detention is if my detention is not authorized by a law, I have not performed any act which is punished or which is considered to be a violation of a law. In that case, automatically my detention becomes illegal. My detention is not valid. and the Supreme Court or the court would declare my detention to be illegal, and it would direct the concerned authority to set me free. Clear? But if the detention has been made under a law, that means there is a law that is present, I have violated the law. The second thing the court looks at is whether that detention or whether the law has been passed by the law should have been passed by a competent authority. That means we already in the Constitution of India, there is something called as state list, there is something called as union list, there is something called as concurrent list, and all these list system does what? It empowers the necessary authority to enact a law. So if there has been a law that has been enacted by the Parliament of India, if it has been enacted by the Parliament of India, what does that mean? It means that if there is a subject that has been mentioned in the union list, in that case the Parliament of India is the concerned competent authority. So if I have been detained under a law and the law suppose deals with a subject that is mentioned in the union list, so who is the competent authority? The Parliament of India. So when I say the Parliament of India is the competent authority, the court would look into this. Who is the competent authority and whether the competent authority has passed the law or not. So if it deals with suppose the state list, something that is mentioned in the state list, Parliament is not the competent authority. And if the Parliament has passed a law on it, it would become the law is illegal, it is unconstitutional, and hence the court would declare the law to be unconstitutional and set me free. On the other hand, if the subject has been mentioned in the union list and there has been a law that has been passed by the state legislature, it is not it's not a competent law, and hence what would happen? My detention would be declared illegal, I would be set free, the law itself would be declared as unconstitutional. Clear? So the second thing that the court looks into, the second idea that the court looks into is whether there has been a competent authority and whether the competent authority has passed the law or not. If the competent authority has passed the law, if the competent authority has passed the law, then what will be seen? What will be seen is whether the said procedure has been followed or not. Whether the said procedure has been followed or not. While you were enacting, or while the concerned legislature was enacting the law, so in that enactment, whether the concerned procedure, the established procedure that has been mentioned in the law, that law, whether the established procedure has been followed or not. Whether the established procedure has been followed or not. Clear? In this case, in procedure established by law, if the court finds that the law, there is a law that is in existence and the law provides for my detention. The act that I have performed, it establishes that there is a act which is a violation of a law. Whether I have been detained under the act or not, the court will see that. Then the court will see the second idea, whether the competent authority has passed the law or not. If the competent authority has passed the law, The court would look into what? The court would look into whether the concerned or the established procedure that has been mentioned in the law, whether that established procedure has been followed or not. And if all these three, provisions have been followed, my detention will be considered to be legal. My detention will be considered to be legal. Clear? This is what is meant by procedure established by law. The term procedure established by law under Article 21 of the Constitution means this. One more time, very important. So suppose the state has deprived me of my right to life and personal liberty. So if the police has detained me, the police has detained me. In that case, my detention, whether it is legal or not, if I appeal it in the court is going to look at what? The court is going to look at the legality of my detention. कि किसी को भी arbitrarily, you cannot detain any individual arbitrarily. There should be some mechanism for detention. Like Article 21 says, the state cannot deny right to life and personal liberty except for a procedure established by law. So what is that? What ensures that legality of my detention? If there is a procedure that has been established by law and the concerned authority has followed that procedure, that is what establishes my legality of my detention. Clear? Let's look at this as from an example point of view. Going back a few months, you must have heard about a case in which one of the individuals from a political party came up with she did what? She came up with a picture in which she had actually photoshopped the picture imposing the face of Mamata Banerjee over a particular picture of Priyanka Chopra. And because of that Photoshop that she had actually, a photoshopped picture that she had actually posted on the social media, she was detained. She was detained by the police. Now what did she do? She went to the Supreme Court, challenging her detention. And as soon as the Supreme Court heard the case, the Supreme Court declared the detention to be illegal. The Supreme Court said, no, you cannot detain in this manner. She was exercising her right to freedom of speech and expression. You cannot detain that. No, you cannot detain an individual on that particular ground. Why? Because is there a law that exists which talks about any such ideas? Which talks about that you cannot post such an idea on the social media or something like that. Is there a law that exists? No. So that detention automatically is illegal. The detention is automatically illegal. So when she challenged her detention, the legality of her detention, how was it challenged? It was under Article 21. Because Article 21 provides us the fundamental right to personal liberty. Personal liberty means what? I have all those rights that are mentioned under Article 19 of the Constitution. All those rights I have. And I cannot be denied of that particular rights. Like I have the right to movement, etc. You cannot detain me. There is no such law talking about, you cannot post any such picture or something like that. So she did that. She photoshopped that particular picture, posted it on the social media, got arrested for it. That kind of detention is absolutely illegal. That kind of detention is absolutely illegal. And she went to the court on this very ground that she has been denied of her fundamental right to personal liberty under Article 21. Clear? Similarly, the same, similar case was there in the state of UP when there was a journalist who had written against the chief minister. Though what he had written was, it was some personal remarks that he had written against the chief minister of UP. But because of this, he got detained. He was detained by the police for doing such a thing. He also went to the Supreme Court. The Supreme Court said you cannot take up any such detention. Even if the individual has made a personal remark, it does not mean it is illegal. It is not illegal. And that detention is not legal. That detention is not legal. Doing what? Declaring the detention to be illegal and setting both those individuals free. Initially, the Supreme Court, while actually जो West Bengal में जो case हुआ था, in that case when the Supreme Court was actually declaring the detention to be illegal, the Supreme Court first of all came up with the Supreme Court came up with a rider that you will be released only if you come up with a written apology against for the chief minister that you have done something like that. The side individual said, no, I will not apologize. It was heard it was heard in a different court. Supreme Court, different bench, heard the same matter, said no, there is absolutely no need for an apology. That is a freedom of speech and expression. Every individual has freedom of speech and expression, and that is a form of expression. So how can you declare or how can you order an apology for exercising freedom of speech and expression? The Supreme Court declared it to be illegal. The detention was declared to be illegal, and no such conditions was imposed that you have to apologize to the chief minister. Nothing of such happened. She was released under Article 21 of the Constitution. Clear? Absolutely clear. So as soon as I challenge my detention, the court would look at first, is there a law prescribing my detention? I have performed an act. Is there a law which says that this act, if you perform this act, in that case you will be detained? Secondly, has the law, if there is a law that is in existence, has the law been passed by a competent authority? And if the competent authority has passed the law, was the said procedure that has been mentioned in the law or mentioned in the Constitution, has the said procedure been followed or not? Clear? And if all these provisions, all these 3 points are they are seen to be valid, in that case your detention is declared to be legal. This is what is meant by procedure established by law. Absolutely clear? Can I move to due process of law? Now, how is procedure established by law different from due process of law? How is it that procedure established by law is different from due process of law? Why is it considered to be different, and why in the Menka Gandhi case, while taking a broader broader interpretation of Article 21, why did the Supreme Court say that procedure established by law should be read as due process of law? There is no difference between them. Why did the Supreme Court say this? Because, similar example, if I have been detained and I challenge my detention in the court, the first thing that the court will see is, obviously, whether there exists a law prescribing my detention or not. Second, whether the competent authority has passed the law or not. Third, whether the said procedure has been followed or not. Whether the said procedure has been followed or not. However, when it comes to due process of law, the court is also, not only the court is going to look into these three criterias, but the court, while declaring the detention to be legal or illegal, will add a criteria. And what would be that criteria? The court would also look into whether the law under which I have been detained, whether the law is a just law or not. That means the court, when the court reads it as due process of law, the court is not looking just at whether the law is there, whether the law has been passed by competent authority or not, or whether the said procedure has been followed or not. The court is not just looking into that, the court is also further going into the justification, or the court is looking into the nature of the law. If the law seems to be arbitrary, whimsical and not justified, the court would declare the law to be unconstitutional, and the court would do what? The court would declare your detention to be illegal and would set you free. एक एग्जाम्पल से समझते हैं. Going back around 3 to 4 years, the same idea of detention of an individual on the same grounds that they had written something on the social media was done. There were two sisters from the state of Maharashtra, and they were detained on the grounds that they had criticized a particular politician, and because they had actually done that on social media, that was a punishable offense under section 66A of the IT Act. If we go now and see, there is a law which deals with this idea, IT Act. It was enacted in the year 2000. It was amended in the year 2008. So an IT Act prescribes, section 66A of the IT Act prescribes that if you make such a statement against some politicians or something like that on social media, it is a punishable offense. The law says that. So if you go by procedure established by law, the procedure established by law says, is there a law prescribing detention? Yes, there is. Has the law been passed by competent authority? Yes. Parliament passed the law. Was the procedure passed? No. Was the procedure followed while taking up detention? Yes. The procedure was also followed. Which means if we look at that very case through procedure established by law under Article 21, just reading it as procedure established by law, the detention is absolutely legal. There is no problem with the detention. The detention is absolutely legal. But what does due process of law say? The due process of law not only judges the law on this ground or the detention on this ground that there is a law, the procedure has been followed and the competent authority has enacted the law. The court also looks into this matter in this manner, that whether the law is just or not. Is the law whimsical or arbitrary? Whimsical and arbitrary. Do you understand now? What is the meaning of whimsical? Whimsical means something that may not be justified. Because you are in a position of power, so you are doing something that is not justified. So if the court looks into this matter as well, whether the law is whimsical, whether the law is arbitrary, and if the court finds the law to be arbitrary and whimsical, the court declares the law to be unconstitutional and does what? Your detention is declared to be illegal and you are set free. So the court looked into that matter from this ground. Section 66A was declared to be unconstitutional. So the Supreme Court went ahead and said, how can 66A be constitutional if it violates our fundamental right under Article 19(1)(a), which provides us the right to freedom of speech and expression. It provides us the right to freedom of speech and expression. And when you come up with certain provisions denying citizens of that particular right through a law, the law cannot be justified. The law was declared to be arbitrary. The section 66A of the IT Act of 2000 was declared to be unconstitutional as it is contrary to the fundamental right under Article 19(1)(a). Both of those two sisters, their detention were it was declared to be unconstitutional and the Supreme Court set them free. Clear? Now do you understand? Do you get the difference between due process of law and the procedure established by law. If you get the difference, what is the primary difference that you see here? अगर आपको ये बात समझ में आ गई है, what I am trying to say, what is the primary difference? Yes. What looks like judicial review? This is not judicial review. Due process of law is judicial review and procedure established by law is not. How did I define judicial review? No. Yes, interpretation by the Supreme Court on what grounds? Interpretation of what? Yes? No, that is not judicial review. What is written in the Constitution, I absolutely agree with that. But what is being reviewed?
The basic structure of the law.
What is being reviewed? Acts of whom?
State. Individual. Fundamental right. If it is not violating fundamental right of individual.
It is not violating, that is absolutely correct. देखो मैंने ये कहा था, I said this, judicial review is the power of the High Court and the Supreme Court to review the acts of the legislature and the executive on the grounds of its constitutional validity. ये कहा था ना? So how is this not judicial review? How is only this judicial review? Both of them are judicial review. So what is the primary difference? I have actually explained what is procedure established by law, and I have also explained what is due process of law. I am just asking you a very simple question. The question is, what is the difference between procedure established by law and due process of law? The difference is that if you look at procedure established by law is a check on the arbitrary actions of the executive. Due process of law is a check not only on the arbitrary actions of the executive but also on the arbitrary action of the legislature. यही तो है ना? फिर से समझो. What is procedure established by law? I am being detained by the executive. I am challenging my detention. I go to the Supreme Court. The Supreme Court sees, is there a law in existence? If there is a law, has the competent authority passed the law? If the competent authority has passed the law, has the executive followed the procedure mentioned in the law? If the procedure has been followed, fine. So if any arbitrary detention has been done by the executive, wherein executive has either not followed the law or the executive has not followed the procedure mentioned in the law, in that case my detention is declared as illegal. But in this case, due process of law, not only is the judiciary checking the arbitrariness of the actions of executive, wherein the judiciary is saying, is there a law? Yes. It has been passed by competent authority? Yes. Procedure has been followed? Yes. Arbitrary actions of the executive has been checked. Now, what is the fourth idea? Is the law arbitrary? When you actually are coming up with this criteria, whether the law is arbitrary or not, in that case, what are you trying to do? You are trying to check the arbitrary actions of the legislature. कि क्या legislature ने कोई ऐसा law तो पास नहीं कर दिया जो arbitrary है, जो whimsical है, जो justified नहीं है. And on this grounds, what does the judiciary do? The judiciary is not only checking the arbitrary actions of the executive but also checking the arbitrary actions of the legislature. Now, is due process of law a wider check or a wider idea than procedure established by law? Yes. And that is the reason why in the Menka Gandhi case, the Supreme Court, while expanding the scope of Article 21 of the Constitution, also imposed an additional check on the power of the legislature by reading procedure established by law as due process of law. Have you understood this idea? If you have not, I will explain it again. But again, as I said, if you just try and understand this by, in the book, you will not get this. Procedure established by law means there should be a law prescribing for my detention. The law should be passed by a competent authority, and the procedure mentioned in the law with respect to my detention should also be followed. If all these are followed, my detention will be considered to be legal. When we look at when we read procedure established by law as due process of law, what does that mean? It means not only is the judiciary looking at, while scrutinizing my detention, the judiciary is seeing whether there is a law. If yes, whether it has been passed by the competent authority. If yes, whether the procedure has been followed or not. If yes, an additional check on the arbitrary action of the legislature. That has the legislature passed a law which is whimsical, which is arbitrary, which denies citizens of any of their rights, fundamental rights or not? If yes, then the law is declared to be unconstitutional. So what is the difference? Procedure established by law and the due process of law. The term due process of law is much broader than the term procedure established by law. Why? Because due process of law imposes not only a check on the arbitrary actions of the executive, but also imposes check on the arbitrary actions of the legislature. Whereas procedure established by law only imposes check on arbitrary actions of the executive, not on the arbitrary actions of the legislature. Clear? Absolutely clear? Have you understood this? So just write it in this manner. Okay? If you have not written, please write it in this manner. Existence of a law, passed by a competent authority, procedure has been followed or not. And in this, here just add this law enacted, whether it is just, whether it is whimsical, whether it is arbitrary or not. And finally, in the last, after this, you have written this, just write a statement. Procedure established by law imposes check on the arbitrary actions of the executive. Due process of law imposes check on not only the arbitrary actions of the executive, but also on the arbitrary actions of the legislature. Done this? You have written this? Now write principles of natural justice. Principles of natural justice. Principles of natural justice. Again, let's understand this idea with an example. What is principles of natural justice? See, there was a case in the state of Andhra Pradesh. What had happened was that there was a judge, and he was the judge of a high court there, and he had applied for reservation in the railways on a VIP quota, because judges are given those facilities. They are preferred when it comes to reservation, even if the seats are they are not available. There is a quota system that is present, and he had applied for it. But the quota system has a hierarchy. Now the quota system has a hierarchy, that is, who is to be, initially there are only some seats that are left for them, and who is to receive that reservation, it depends upon who are the individuals who are travelling. So a judge of the High Court will stand lower in the hierarchy than members of the Parliament, members of the state legislature, the judges of the Supreme Court, and then comes the judges of the High Court. So because of some reasons, he was not able to get a reservation. So what he did, as soon as he came to know that, he came to the, when he came to the platform, he came to know that the train that is there, in which he had applied for reservation, his ticket has not been confirmed. He called a court then and there on the platform itself, because judges have the right to do that. They may not necessarily be in the court premises. They can call for a court anywhere. So he called for a court on the platform itself and punished the concerned individual that I was supposed to receive a confirmed ticket, but I did not, and it is your fault. And hence he punished that particular individual by calling the court on the platform itself. When the concerned individual who was punished, he challenged the punishment in a higher court. He challenged the punishment in the higher court. In the higher court, the punishment was declared to be unconstitutional and invalid. What was the ground of it being declared unconstitutional and invalid? The ground was that it did not follow the principle of natural justice. It did not follow the principle of natural justice. Principle of natural justice, or why did it not follow the principle of natural justice? Because principle of natural justice talks about three inherent sub-principles. When I say principle of natural justice, it means there are three other sub-principles that are inherent in it. What are those? First is called as, in Latin it is said to be odi alterum partem, which means no one is to be punished unheard. No one is to be punished unheard. Second, the authorities are to act in a bona fide manner. Bona fide means in good faith. That means it is considered that authorities who are prescribing for a punishment, or authorities who have the institution which has the authority to prescribe for that punishment, that institution is acting in good faith. It does not have any bias against the concerned individual. And third is, no one shall be a judge in his own case. No individual shall be a judge in his own case. The third principle. And what do you see here? The individual who punishes the concerned authority is a judge in his own case. He is the victim, or for that matter, there is something wrong that has happened and it was against him, and he himself is punishing the concerned individual. Obviously, how can you hear a case with absolute, or how can you act in good faith if you are one of the stakeholders in that particular decision? And when the decision of that individual, that particular judge, was said to be unconstitutional, it was said, or the grounds that was mentioned in this, it was this, that this does not follows the principle of natural justice. Why? Because natural justice, one of the principle is no one shall be a judge in his own case, and accordingly an individual is being punished by an individual who is a judge in his own case. Hence the judgment was declared to be unconstitutional. Clear? Now, you must have heard about going back around 2 years, there was a case wherein 21 members or legislative members of the Aam Aadmi Party was declared. It was declared that the president disqualified them from being the member of the Delhi legislature. Why it had happened? Because it had happened on this ground that the election commission had viewed that is these 21 members that are there, they were holding office of profit, and an individual who is a member of the parliament or any legislature cannot hold any office of profit. If you hold any office of profit, in that case you are you can be disqualified on that very ground. You can be disqualified on that very ground. So these 21 members were disqualified, that they were holding office of profit. What is this idea? Later part of our discussion I am going to deal with this as well. They challenged this decision. Now the election commission recommended the president to disqualify 21 members, and the president disqualified the 21 members. However, these 21 members, they challenged such a disqualification in the High Court, Delhi High Court, and the Delhi High Court did what? Stayed the decision. Now, the Delhi High Court stayed the decision, stating that the Election Commission should follow the process again. And what was the ground? What was the ground? Why is it that the High Court stayed that particular decision of the President and said that the Election Commission should follow the process again? What was that particular ground? The ground was that all the 21 members of the Aam Aadmi Party, the legislative members that are there, they had said that election commissions did not interview them. The election commission that was there, they did not interview them. So they were not given the opportunity to explain themselves. They were not given the opportunity to explain themselves. So this was the basic ground on which they went to the court. And the court, because principle of natural justice says what? Audi alteram partem. No one shall be punished unheard. So how can you disqualify them when you have not heard them? And hence the Delhi High Court stayed the matter and directed the Election Commission to do what? Directed the Election Commission to follow the process again. In this time, when you are continuing with whatever process you are following, you will have to interview even all those MLAs of the Delhi legislature. Why? Because they were being punished unheard. So principle of natural justice, it dictates these three sub-principles. First, no one shall be punished unheard. Second, authorities shall act in a bona fide manner, not in a mala-fide. Two terms. Bona fide means what? Good faith. Mala-fide means bad faith. So authorities are always going to act in a bona fide manner. Third, no one shall be a judge in his own case. And in any of this, if any of this is violated, in that case it will be considered as a violation of principle of natural justice. It will be considered as a violation of principle of natural justice. Clear? Now, if you look at the Constitution itself, the Constitution of India nowhere mentions explicitly the idea of natural justice. Nowhere, in no provision of the Constitution, it has been mentioned that principle of natural justice will be, it will be followed. Nowhere it has been explicitly mentioned, and that is the reason why in the AK Gopalan case, the Supreme Court did not incorporate the principle of natural justice under Article 21. In the Menka Gandhi case, the Supreme Court took a wider interpretation and said that principle of natural justice is present under Article 21, which means any individual who is being detained or is being denied of his personal liberty or is being denied of his right to life, in that case the individual can be denied of, yes, the state can do that, because there is something called as due process of law, and if the state has followed due process of law, then such a detention or such a denial of these rights are absolutely legal. But the Supreme Court in the Menka Gandhi case, declaring that Article 21 of the Constitution also incorporates the principle of natural justice, imposed an additional check. What is that additional check? Natural justice. So once an individual is being detained, the individual can be detained not only if the due process has been followed, but also if there is natural justice. Natural justice has been followed. If there is a denial of natural justice, in that case, if the principle of natural justice has not been followed, in that case, the concerned individual's detention again will be considered illegal, and such a punishment will not be upheld by the court. It would be considered as violation of Article 21 of the Constitution, that is right to life and personal liberty. So basically what it means is, if you look at natural justice, ensuring the idea of natural justice or incorporating the idea of natural justice, not only did the court reading procedure established by law as due process of law, not only impose certain checks on the executive and the legislature, but incorporating principle of natural justice, in the Menka Gandhi case, the Supreme Court also imposed the check on the judiciary. The Supreme Court also imposed a check on the judiciary that when an individual is being detained, what we also need to look into is that detention is legal, also satisfying natural justice. So if the court is punishing an individual, denying the individual right to life and liberty, the court will also adhere to certain rules, like the principle of natural justice. The principle of natural justice. Clear? So basically you can see it in these two terms. Either you can see it as the court imposing a check on the judiciary, or you can see the court imposing a duty on the judiciary to ensure that natural justice principles are followed. Clear? Have you understood this idea? And now see, आपने कहा judicial review. You said judicial review. When the court is actually taking up judicial review, when the court is looking at the constitutional validity of a particular act, don't you think the court is also following the principle of natural justice? If the court feels that any provision, any act does not meet such criterias, the court will declare the law also to be unconstitutional. If in any such cases, if such provisions are there. Clear? So natural justice is not only a check on judiciary, it can also be understood as a duty of the judiciary to ensure that there is absolutely no arbitrariness in any kind of detention. Whether that arbitrariness comes from executive acts, whether the arbitrariness comes from legislative acts, or for that matter, arbitrariness comes from judicial acts. There is no arbitrariness present while an individual is being denied of his right to life and personal liberty. It should be just. It should be a just mechanism. It should not be arbitrary. Otherwise, we are defeating the very idea of a democratic state. We are defeating the idea of fundamental rights if there is even a slight scope of arbitrariness. And the manner in which in the Menka Gandhi case the Supreme Court interpreted Article 21, the Supreme Court removed any scope for arbitrariness in such decisions, upholding not just the idea that we follow a democratic state, we prefer or we give preference to the rights of citizens by ensuring such a principle. Clear? Absolutely clear? Now, have you understood this idea? This is about our discussion on Article 21. However, going back to our previous discussion, we did talk about something called as contempt of court powers. And in contempt of court powers, I said that contempt of court is criticized on various grounds. The first ground is that obviously it is against the idea of freedom of speech and expression. So if I am speaking against the decisions of the judiciary, I might be punished for it. So it is basically contradiction of our idea of freedom of speech and expression. Not only that, the concept of contempt of court is also criticized on this ground, that it is a violation of natural justice principle. It is a violation of natural justice principle. Why? Because it is said that the court, the judiciary or the individual who is punishing an individual because of contempt or on the grounds of contempt of court, the individual may be the judge who has presided over the decision that has been given by the judiciary. That would be what? That would be a violation of natural justice principle. That would be a violation of natural justice principle. And to take care of this, there was the Parliamentary Committee on Law and Justice recommended, the Parliamentary Committee on Law and Justice recommended that there should be an amendment made to the law, there should be an amendment made to the Contempt of Court Act 1971. Accordingly, there was an amendment made to the Contempt of Court Act 1971. The amendment included two ideas. First, truth was considered to be a justification. So even if an individual has criticized the decision of the court but is able to prove that what he has spoken is absolutely true, in that case he should not be there should not be any kind of punishment that should be imposed. Secondly, the court within itself has issued a directive that when there is a contempt of court proceedings are going on, the judge who has presided over the original decision will not preside over the decision of the contempt of court proceeding that is going on. Though sometimes it is still violated. And the example of this is, if you remember, very recently, Ranjan Gogoi, the Chief Justice of India, there was an allegation of sexual harassment against Ranjan Gogoi, and he presided over, he was one of the judges who was presiding over such, when hearing of such allegations was going on. That should not have been done. It is a violation of principle of natural justice. It is a violation of principle of natural justice. It should not have been done. Clear? This is what Article 21 of the Constitution and some part of our discussion on contempt of court that was there, it was, this was something that was left. I have taken both of them into account. Clear? Yes. See, when it comes to actually the procedure that the court follows, if you look at the Constitution itself, the Constitution empowers the court to decide the procedure. So, when it comes to the cases that are registered and the cases that are registered to whom or which bench, which judges it is referred to, it is decided by the Chief Justice of India itself. So, it is his discretionary power under the Constitution of India. But ethically and morally speaking, he should not have done that. In terms of legally speaking, yes, he has the authority because that is provided under the Constitution. But ethically and morally speaking, he should not have done that. No, that cannot be challenged because it is the Chief Justice who himself would decide. So he is himself deciding. So it can legally it was not wrong, but morally, and if you go by this idea, it was wrong. Clear? Write down. Principles of natural justice. It includes three principles. First, no man shall be punished unheard. No man shall be punished unheard. In brackets, write Audi Altrem Partem. Audi Altrem Partem. Second, no man shall be a judge in his own case. No man shall be a judge in his own case. In his own case. Third, an authority shall act. An authority shall act in a bona fide manner. In a bona fide manner. That is in good faith. In good faith. Next paragraph, right? The objective of principle of natural justice, the objective of principle of natural justice is to ensure a degree of fairness in the decision making process degree of fairness in the decision making process and exclude arbitrariness, बाहर बोलिए उनको चुप रहने के लिए, ऊपर चले जाना, arbitrariness in decisions taken. They emphasize that decisions shall support reasoning. They seek to humanize the decision making process. They are universal principles. According to the Supreme Court, they are not incorporated but inherent principles of the Constitution. They are enjoyed by all individuals. And are binding on all authorities. Both public and private, and individuals as well. Further, in the Central Inland Water Transport versus Bhojnath Ganguly. Versus Bhojnath Ganguly, 1986 case. The Supreme Court declared that principles of natural justice are also found under Article 14. They are regarded as one of the pillars over which our constitutional philosophy has been built. It is also regarded as a part of basic structure of the Constitution. Underline Article 14 and basic structure. You must have heard about tribunals, various tribunals that are there. What do you feel is the objective of establishing tribunals? Article 323A of the Constitution deals with the power of the Parliament by a law establish tribunals. My question is, what do you think is the objective of establishing tribunals? Like, you must have heard about one of those tribunals like the NGT, National Green Tribunal. it tends to regularly be in news. My question is, what is the objective of establishing a national green tribunal? Why not this work to be done by the court? Because that is what the tribunals also do. They look, they come up with judgments on certain issues. Like the Green Tribunal, National Green Tribunal has the objective of coming out with any kind of environmental judgments that are there, or any issue which relates to environment or something like that. It is appealed and it is heard in the National Green Tribunal. So there is an overlap that is there with the functions of the tribunal and the function of the courts. My question is, then why do we actually come? What is the need for tribunals? Why isn't these matters appealed in the court? As one of the ideas that she says is that it lowers the burden of the judiciary. We have already seen there are a lot of pending cases on the judiciary, and hence it lowers the burden of the judiciary. Absolutely correct. But do you think that is the only reason? Who heads the tribunals? ट्राइब्यूनल्स को कौन हेड करता है? जजेस. हाँ, बट क्या? How? That is what I am asking. If it is headed by judges itself, so judges are there in courts. Judges are there in High Court, Supreme Court. All of them are also judges. So when it comes to tribunals, they are also headed by judges. So what is the difference?
The law which they follow.
What is the law that they follow? There is a 2010 law. So what does the law say about NGT? इस तरह समझो. What she says is absolutely correct. What she is also saying is correct, but she is not actually able to put it in that manner. When we talk about tribunals are only being headed by judges. There are other members as well, and these members are not necessarily judges. So if you look at the courts have the judges that are there who are presiding over courts. They have only legal sense. They do not have specialized or administrative sense. And tribunals are formed because of this very idea, because tribunals do what? They provide for that specialization. So if there is anything that is related to environment, and if you look at the composition of NGT, you would find, if you look at the 2010 law, it says though it is to be headed by a judge, but other members that are there, they may belong to a very specialized field. Like they may be individuals who are appointed by the government as experts to the tribunals. तो वो flexibility मिल जाता है. Not only just the legal sense, but they also have that administrative specialized sense. ठीक है? And if you look at these tribunals do not follow a set procedure code. Like courts have criminal procedure code, civil procedure code. Tribunals do not follow these codes. So how does the tribunal work? Tribunal works on the principle of natural justice. Tribunal works on the principle of natural justice. So they have been given the flexibility. They have been given the flexibility to deal with one particular issue in the manner that they want. So they all have the powers that a court has. Like the court has the power to ask for presence of an individual. You are ordered to be present. The same powers are also there with tribunals. But the court follows procedure code. There is a procedure in which the court works. That is not there with the tribunals. So what is limitations on which these tribunals follow? What are the limitations? The limitations is that they work on the principle of natural justice. So any decision that a tribunal gives, it should not be a violation of natural justice. So that is the reason why you have written that it is applicable to all authorities, private, public, as well as individuals. Underline that. Remember this. no authority can violate the principle of natural justice. No authority can violate the principle of natural justice. There may be laws which would prescribe, or there may be some ambiguous nature of the powers that some authorities enjoy. Article 324 of the Constitution, it deals with election commission. If you look at Article 324, it says election commission has the power to do what? Election commission has the power to conduct elections, and in this conduct of elections it has the power to prepare electoral rolls. It has the power to direct, coordinate, control the conduct of elections. So when we say direct, control and conduct elections, which means it has all the powers: superintendence, control, direction of elections. So is there any limitation to the power of election commission? Yes, natural justice. It is a limitation to the power of election commission. All authorities, not just election commission, all authorities, tribunals, authorities, courts, etc., they are all limited by the power of natural justice. As you have written initially, it has the objective of what? It has the objective of introducing fairness in the decision making process. So no arbitrary decisions. No arbitrary decisions. Clear? With this, we complete our discussion on Article 21 of the Constitution. What you have to refer here is, you will refer Lakshmikant and you will see what over a period of time, what are the rights that have been declared by the Supreme Court as inferred rights under Article 21. This is what you should have seen yesterday itself, but if you have not gone through it, please go through it. Clear? What are the rights that have been declared by the Supreme Court as inferred rights under Article 21? Though UPSC does not ask this question, UPSC questions are more technical in nature, it is more about your understanding, but it may so happen that you get this if you are suppose giving examinations for suppose state services or something. In that case, sometimes it is asked. Clear? So you should have that particular knowledge, and you never know, it might be asked in UPSC as well. Clear? Next, Article 21A. Article 21A. It was introduced by the Constitution. It was introduced in the Constitution. It was introduced in the Constitution by the 86th Constitutional Amendment Act. 86th Constitutional Amendment Act in the year 2002. 2002. It says that the state shall provide free and compulsory education. The state shall provide free and compulsory education to all children within the age of 6 to 14 years, within the age of 6 to 14 years, in a manner as provided by law, as provided by law. Clear? So the 86th Constitutional Amendment Act 2002 made right to education a fundamental right by adding Article 21A of the Constitution. However, qualitatively speaking, Article 21A which provides explicit, it provides that right to an explicit right to education as a fundamental right. If we go back to the 1990s, there was a case Unni Krishnan versus the state of Andhra Pradesh. And in this particular case, in the 1990s, to be very exact, in 1993, the Supreme Court had already declared that education, right to education to children within less than 14 years of age, they have the right to education and it is a fundamental right. The Supreme Court had already declared it in the 1990s itself. However, Article 21A of the Constitution makes it an explicit fundamental right. It was before that in the Unni Krishnan case, it was an implicit fundamental right that was declared by the Supreme Court. The Supreme Court declared it to be a part of fundamental rights. But there was a difference between what the Supreme Court had to say and what Article 21A says. The Supreme Court says, in the Unni Krishnan case, the Supreme Court declared that right to education is a fundamental right for all children below the age of 14 years. Below the age of 14 years. Article 21A says in between the age of 6 to 14 years. So it limits the right from, you will find that generally in the contemporary times, right education does not start at the age of 6 years. It starts at the age of 2.5 or 3 years. Which means by this particular constitutional amendment, the fundamental right was not extended, rather it was limited, because the Supreme Court had to say any child below the age of 14 years has the fundamental right to education. But the law says 6 to 14 years, which means if you look at 3 to 6 years, by this particular constitutional amendment, they were denied the right. 3 to 6 years, children between the age of 3 to 6 years, they were denied that particular right to education. But very recently, if you look at the national education policy, which was very much in news because it had that 3-language policy, 3-language issue, and one of the language that was made compulsory was Hindi. So it created an issue in the southern part of the state of India, etc. If you look at that particular education policy, it further says that right to education law, which was enacted in the year 2009 and implemented in 2010, it should be expanded to include not only children between the age of 6 to 14 years, but it should start from 3 to 14 years. So the right that was declared initially by the Supreme Court, somehow the government is trying to integrate that under the education policy. Clear? It may so happen that you might see a amendment done to the Right to Education Act and include this very idea of 6 to 14 years that is there, it is changed and it is from 3 to 14 years and not 6 to 14 years. That may be an amendment that will be made, or for that matter it is implemented through an executive direction, not necessarily needed for an amendment. Clear? The 86th constitutional amendment did not just add a fundamental right, it also added a fundamental duty. Write this. The 86th constitutional amendment also introduced the 11th fundamental duty under Article 51A clause K, which states that it shall be the duty of every citizen to provide opportunities for education opportunities for education to his children between the age of 6 to 14 years. Between the age of 6 to 14 years. The Parliament has enacted right of children to Free and Compulsory Education Act, to Free and Compulsory Education Act 2009, which was implemented from the 1st of April 2010. 1st of April 2010. Which means what? We have completed 10 years of right to education, which makes the law very important. So, in the upcoming mains examination, you might get a question on right to education. Because we have completed 10 years, or by 2020 we are going to complete 10 years of implementation of this particular law. So it was expected that it might be asked this year, but because it was not asked, so again it is important for next year. Next, Article 22. Article 22. This article is also, if you look at the nature of this article, it is also as important as Article 20 and 21 of the Constitution. When we say lack of arbitrary detention, so lack of arbitrary detention or lack of arbitrary laws made by the Parliament for detaining an individual, or lack of arbitrary executive actions like the double jeopardy, or for that matter the providing self-incriminating evidences. In the same nature, Article 22 of the Constitution is also very important. What is it? Let's look into it. Write down. It deals with protection against arrest and detention. In certain cases, these are first subpoint. No person who is arrested shall be detained in custody without being informed of the grounds for such arrest. So if I have to be arrested and I am being arrested and further I will be detained, in that case I have the right to know about my grounds of arrest. I have to know about the grounds of my arrest. No one can just say that you are being arrested without informing me about the grounds. Clear? That cannot happen. Further, in the same point, right? The Supreme Court in the Joginder Kumar versus the state of UP. Joginder Kumar versus the state of UP. 1994 case clarified that an arrested person, has the right to inform his friends, relatives, or someone else about his arrest. Further, his arrest shall not be merely on the grounds of suspicion. And a reason should be recorded. By the police officer in his official diary. Obviously, see, this particular direction that has been given by the court, it is given so that there is no arbitrary arrests, or for that matter, there was going back again, as I said, going back 10, 15, 20 years, you will find that there were lot of cases in which custodial deaths used to happen, fake encounters hota tha, all these things, and for this there has been some specific directions that have been imposed. Like if we talk about some additional guidelines that have been given. In various cases, the Supreme Court has said that when it comes to women cannot be arrested in between 10 p.m. to 10 a.m. They cannot be arrested during this particular ground until unless it is very urgent. Until unless there is a flight risk, they cannot be arrested. If women are to be arrested, in that case it is mandatory for them to have a women police officer present during the time of arrest. Similarly, women can also not be interrogated during the same period. That means if they are arrested from 10 p.m. to 10 a.m. they cannot be subjected to any kind of interrogation. So all these things are there. Over a period of time, the Supreme Court has evolved some directions for the police to follow, because there has been number of cases of police atrocities, lack of accountability. There has been custodial deaths. जब custodied में death हो जाता था, generally they are not being recorded in their official diary that they have picked up some individual or something like that. So if custodial death is there, so they used to do what? They used to disown the individual, that no, we never arrested him or something like that. This was something that was very frequent, and because of this, Supreme Court has come up with detailed directions and guidelines as to what the police should follow. Clear? Second point. The arrested person shall be allowed to consult and be defended. By a legal practitioner of his choice. Again, a right that every individual who is arrested has. You have the right to be defended. It cannot be that you are without defense. Third, every person who is arrested and detained shall be produced before a nearest magistrate within 24 hours of his arrest. However, while calculating the 24 hours, holidays and time taken to travel from the place of detention to the court, from the place of detention to the court shall not be taken into consideration. Shall not be taken into consideration. So within 24 hours, any individual who is arrested shall be produced before the judicial magistrate, and while calculating the 24 hours, if there are some intervening holidays that is not calculated, obviously the time taken to travel from the place of detention to the judicial magistrate, that is also not calculated. Clear? So sometimes you will find individuals being arrested on Friday. Why? Because Saturday and Sundays are holidays. So that is not taken into consideration. So they will be produced in the court on Monday. Sometimes this also happens. Clear? Fourth, no person who is detained in custody shall be detained beyond the period for which his detention has been authorized. His detention has been authorized by a judicial magistrate. By a judicial magistrate. See, what happens is, as soon as the police produces a detained or arrested individual in front of the judicial magistrate, there is a preliminary hearing that goes on, which from both the sides, that is from the prosecution and defense, both the sides, the hearing is about whether the individual should continue in detention or not. If the court authorizes that yes, the individual should be detained for suppose 10 days, 14 days. So whatever 10 days, 14 days, now that 10-day or 14-day period or 20-day, whatever is given, now that is the legal period of detention. So on suppose the 10th day, now once the 10th day is complete, now that detention is illegal. You cannot detain an individual beyond that period. So he has to or she has to be produced again in the court, and in the court the prosecution or the defense will again hear, it would be heard, the case would be heard, and accordingly whether the detention is to be extended or it should, it is not to be extended is decided. Like the example of it, this is P. Chidambaram. Okay. When he was detained, the next day his detention was appealed in the court. The court said we are going to hear the matter 2 days. No, there will be 2 days before we hear the matter, because it was holiday or something like that. So it was heard that day. The court authorized that this detention is legal and he will continue in detention for a certain period. Now as soon as he is detained, now what happened, he was shifted to Tihar jail, that now he is under detention, and for that almost more than 100 days have passed and he has been kept under detention. Why? Because frequently it has been argued in the court, the concerned authority has asked that whether he should be detained or not. They have talked about, the judges have decided that no, he will be under detention. Clear? So he is under legal detention. If suppose 14-day period or 10-day period or whatever date has passed, and if you still detain, if the executive still detains that individual, that detention is illegal. It is not legal. Clear? Clear? Now, before we get into exceptions of Article 22 of the Constitution, what do you think is the relationship between Article 21 and Article 22? We have gone through Article 21. We have now also gone through Article 22 of the Constitution, the rights that are given to us under Article 22. So we have seen Article 21 says, the state shall not deny an individual his right to life and personal liberty except for a procedure established by law. And Article 22 of the Constitution also gives 4 conditions when an individual is to be detained, or what will be the manner in which the individual is to be detained. So what is the relationship between Article 21 and Article 22 of the Constitution? Yes.
Detention which is done is as per the just law.
Just law or not? Is that the relationship between? What is the relationship between Article 21 and Article 22 of the Constitution? इतना डिफिकल्ट नहीं है. देखो, या तो आप फिजिकली प्रेजेंट हो, ठीक है. फिजिकली प्रेजेंट होने का मतलब समझ रहे हो, यू आर मेंटली एब्सेंट. आइदर दैट इज द केस और यू हैव अंडरस्टूड व्हाट आई हैव सेड.
Told by Article 21 and the procedure after the detention told by the Article 22.
Absolutely correct. Procedure established by law. What is the procedure established by law? What is mentioned under Article 22 of the Constitution? What is mentioned under Article 22 of the Constitution? So Article 21 of the Constitution says what? Article 21 of the Constitution says you will not be denied of your right to life and personal liberty except for a procedure established by law. And what does Article 22 of the Constitution do? Article 22 of the Constitution elaborates what is the procedure that has been established by law. This is the relation. This is the relation that is there. Clear? Have you understood this idea? ठीक है, तो there is no need just to be physically present, be mentally present also, because this is not that difficult. ये बहुत difficult question नहीं था. It was very clear as to what is procedure established by law, and it has been elaborated under Article 22. Yes, yes, that is what is the procedure.
So, but like in 21, we have like he should not be denied of personal liberty except the procedure
Established by law.
Like his personal liberty can be denied on the basis of
Procedure established by law.
right? Certain rights.
That is what it is there. When you are being detained, or suppose your detention is legal. So what grounds are mentioned in the law? It should not be violative of Article 22. That means even when it comes to detention, a legal detention, what would a legal detention look like? It has been mentioned under Article 22. It has been mentioned under Article 22 that if I am being detained, in that case also the individual who is detained has certain rights, and those rights should not be violated. This is what Article 22 says. Clear? So that procedure established by law is elaborated under Article 22. Clear? Exceptions. Give us a heading, right? Exceptions. Exceptions have been mentioned where? Under Article 22 clause 3. Under Article 22 clause 3. What does Article 22 clause 3 say? Such protections are not available to a person. Such protections are not available to a person who is detained under preventive detention, or to an enemy alien, that is a foreigner with whose country India is at war with. Clear? So exceptions against whom? Those individuals who are under preventive detention, or an individual who is an enemy alien. Those individuals do not get the same protection that has been mentioned under Article 22. Now, when we say preventive detention, see, detention can be of two types. First is preventive and punitive. Preventive detention means what? Before the crime has been committed, and punitive detention means what? After trial. After trial. That means once the court has heard the matter and the court has declared an individual to be guilty of an offence, and then whatever punishment is done, and if the court prescribes for detention, that kind of detention is called as punitive detention. And then there is preventive detention, which means before the crime has even been committed. Before the crime has even been committed. And any individual under preventive detention does not have this protection. So an individual under preventive detention may not at the time of his arrest be informed of the grounds of his arrest. Jaisa Article 21 lays certain grounds, and what is the first ground? That as soon as you are arresting the individual, you would inform the grounds of his arrest, why he is being arrested, and he has the right to inform someone. That protection is not available to an individual under preventive detention, specifically when it comes to the ground of detention. That is not there. Similarly, an individual under preventive detention may not be given the choice to be legally represented, or the individual may not be produced before the judicial magistrate within 24 hours. No such rights that are there is available to an individual under preventive detention. Okay? Have you understood what is preventive detention? Okay? Before the crime has been committed. But if you look at Article 22 Clause 3, it also says that preventive detention, which is detention before trial, but the ground of preventive detention is that it should always be legal. It does not mean that an individual can be detained, without a law prescribing for preventive detention. Like we have already previously talked about something called as Public Safety Act. So right now, if you look at the state of Kashmir, in Kashmir, certain politicians have been arrested because of this Public Safety Act. Why? Because Public Safety Act prescribes for preventive detention. Public Safety Act prescribes for preventive detention. So an individual can be preventively be detained only if there is a law which prescribes for preventive detention. If there is no law prescribing for preventive detention cannot be done. Clear? This is what is mentioned under Article 22 Clause 3. Have you understood Article 22 Clause 3? Okay? There are some other things, but have you understood till now what we have talked about? Clear? There is also certain limitations that have been imposed under what is preventive detention also can be taken up. It will go, if it has to continue beyond a period of 3 months, till 3 months it is absolutely fine. But if it has to continue beyond a period of 3 months, so there will be a committee that would be formed, and that committee would recommend whether it will continue or not. Now it will not be on the executive itself, it will be on that committee. The committee would recommend whether the detention should continue or not. This has also been mentioned in 22. So there is some check that is imposed on preventive detention also. ऐसा नहीं है बस detain कर लिया और बस जिंदगी भर के लिए वो डिटेन हो गया, ऐसा नहीं हो सकता. क्लियर? सो देयर आर सम ग्राउंड्स दैट हैज बीन इम्पोज्ड एज चेक्स ऑन प्रिवेंटिव डिटेंशन ऑल्सो. ठीक है. नाउ if you look at preventive detention, what is preventive detention? Preventive detention does what? Preventive detention denies an individual of fundamental right or the protection that we have with respect to arrest and detention in certain cases that has been denied to us under Article 22 or when we talk about under preventive detention. Those rights that have been given to us under Article 22 is denied when we have or we are under preventive detention. Clear? Now, just look at the relationship between Article 21 and 22. I am going to elaborate on this a bit. He very correctly said relationship between Article 21 and 22 is the term procedure established by law has been elaborated under Article 22. What is meant by procedure established by law? Now, the court reads Article 21, procedure established by law, as due process of law. It reads procedure established by law as due process of law. So if you go before 1978, that is before the Menka Gandhi case, if you look at the relationship between Article 21 and Article 22, the relationship was what was procedure established by law has been defined under Article 22 as, what are the grounds of that procedure established by law? Post 1978, that is post the Menka Gandhi case. Now if you look at the relationship between the due process of law, that is Article 21, and Article 22, that is, suppose we talk about an individual under preventive detention. When we talk about an individual under preventive detention, now Article 22 of the Constitution legalizes preventive detention. Preventive detention is allowed. But does that mean that an individual under preventive detention does not enjoy any rights? Does that mean an individual under preventive detention does not enjoy any rights? Absolutely wrong. Yes, the individual still enjoys the rights that have been mentioned under Article 21. That is, when we say due process of law is there, and therefore due process of law ensures that there is no arbitrary detention. Even if it is on preventive grounds, there is no arbitrary detention of any individual. Even an individual under preventive detention can appeal to the court, and the court, while looking at the detention, would see whether there is a law. If there is a law, it has been passed by competent authority. If it has been passed by competent authority, procedure has been followed. If procedure has been followed, is the law justified? It does not mean कि मैंने पार्लियामेंट ने एक लॉ पास कर दिया प्रिवेंटिव डिटेंशन का और बाकी सबको अरेस्ट कर लिया. ऐसा नहीं कर सकता है पार्लियामेंट. पार्लियामेंट डज नॉट हैव द अथॉरिटी टू डू दैट. Why? Because Article 21 of the Constitution says due process of law, which means even an individual under preventive detention can appeal to the court, and while the court is looking at the detention, the legal nature of that detention, the court will see that such a preventive detention that has been taken up, whether it is arbitrary or justified. If the court finds that even preventive detention is arbitrary, it would declare the detention to be illegal. अरे कुछ तो ग्राउंड होगा, ऐसे थोड़ी ना आप कर लोगे किसी को भी अरेस्ट. कुछ तो ग्राउंड होगा जिसमें ठीक है लॉ प्रिस्क्राइब्स फॉर प्रिवेंटिव डिटेंशन, बट देयर हैज टू बी सम ग्राउंड. अगर मुझे डिटेन कर लिया, पुलिस ने बोला प्रिवेंटिव डिटेंशन के अंदर है, अरे क्यों रखा है मुझे, मैं क्या कर रहा हूं ऐसा, कुछ तो बताओगे. That is what is due process of law, and it ensures that due process of law ensures that even preventive detention is not arbitrary. Clear? तो अगर हम 1978 और पोस्ट 1978 देखते हैं, आर्टिकल 21 एंड 22 इज ऑलवेज रिलेटेड. Article 21 of the Article 22 of the Constitution previously used to prescribe what is procedure established by law. But when we read procedure established by law as due process of law, now Article 21 also contributes to what is Article 22, prescribing or ensuring that even preventive detention is not done arbitrarily. Why? Because there is due process of law. Clear? So yes, you will not be informed about your, when you are being detained, you will not be informed about the reason or under what grounds you are being detained. बट ऐसा नहीं है कि अनलिमिटेड पीरियड के लिए आप इन्फॉर्म नहीं करोगे, उस समय इन्फॉर्म नहीं कर सकते, बट एज सून एज पॉसिबल यू आर टू बी इन्फॉर्म्ड ऑफ योर ग्राउंड ऑफ अरेस्ट as soon as possible. Yes, you will not be produced before the judicial magistrate, but it does not mean I do not, if I am an individual under detention, I do not have the right. No, it does not mean I do not have the right to appeal in the court against that detention. I still have the right because due process of law says so. Even an individual who is under preventive detention, ठीक है, थोड़ा और लीगली देखोगे ना, बिकॉज ऑफ ड्यू प्रोसेस ऑफ लॉ अंडर आर्टिकल 21 द इंडिविजुअल अंडर प्रिवेंटिव डिटेंशन आर गिवन मोर राइट्स देन एन इंडिविजुअल अंडर प्यूनिटिव डिटेंशन. Why? Because the individual has not performed any kind of crime, so you cannot just detain the individual and deny him all rights. No, the individual has not performed a crime, you have preventively detained him. So that is not a ground for penalizing the individual or punishing the individual. So that detention that is there, it will also have to satisfy the fact that there are certain specific rights that the individual would enjoy under detention. ज़्यादातर पॉलिटिकल डिटेंशंस होते हैं प्रिवेंटिव डिटेंशन में, ज़्यादातर पॉलिटिकल डिटेंशंस होते हैं. सो दे enjoy all that rights. Now it is ensured that they have the right to movement. मतलब आपने डिटेन कर रखा है एक प्रेमाइस में, बट इट डज नॉट मीन कि आप एक रूम में बंद कर दो, जेल में बंद कर दो, ऐसा नहीं. उनको पूरा राइट टू मूवमेंट होता है. दे कैन मूव बियॉन्ड इन दैट प्रेमाइसेस इटसेल्फ. व्हाट इज द लिमिट? बट दे हैव दैट लिमिट. उनको न्यूज़पेपर्स वगैरह दिया जाता है. यू आर एबल टू रीड, यू गेट टू नो व्हाट इज गोइंग ऑन. ऑल दीज थिंग्स दैट आर देयर, दे आर प्रोवाइडेड. व्हाई? बिकॉज द इंडिविजुअल इज नॉट अंडर प्यूनिटिव डिटेंशन. So the individual has not just not performed a crime. So the individual will be provided some additional rights. Clear? So what is the relationship between Article 21 and Article 22 of the Constitution? Article 22 of the Constitution contributes to Article 21, wherein it describes or it actually elaborates what is meant by procedure established by law. And Article 21 of the Constitution also contributes to Article 22 of the Constitution when it elaborates or it ensures that even those individuals who are under preventive detention are not denied due process of law. Clear? This is the relationship between Article 21 and Article 22 of the Constitution. ठीक है? Have you understood this? ये सारी चीजें लक्ष्मीकांत में नहीं दी हुई हैं, so don't assume that you are going to read it later on. ठीक है? You should have this knowledge right here, right now itself. ठीक है? It's not that it will be asked as a separate question, but you should know this relationship because it does what you know. If you know such a kind of relationship, it will not be directly asked, but it substantiates your answer. If you have the capability to present such information in your answers, it actually substantially improves the quality of your answers. Clear? So if you ever get a question on Article 21 or Article 22 of the Constitution, or for that matter a broader question on fundamental rights, and you have to write certain things, you can always present this. Clear? Understood this? Right. Exceptions, Article 23 clause 2, you have already mentioned preventive detention. After that you can write an individual under preventive detention. An individual under preventive detention has been detained without a trial the detainee might not have committed a crime at all and might be arrested and detained merely on suspicion. The objective of preventive detention is to prevent him from committing a crime of socio-economic nature. The state does not have the power to detain an individual under preventive detention without the authority of a law. The state legislature do not enjoy the right to enact preventive detention laws. Underline do not. ठीक है, डोंट मिस नॉट. आपने हो सकता है आप में से किसी ने डू लिखा होगा, नॉट छोड़ दिया है, फिर बोलोगे सर ने गलती करवा दिया. डू नॉट एंजॉय द राइट. ठीक है, इट इज डू नॉट डू नॉट एंजॉय द राइट. सो ओनली द पार्लियामेंट हैज द राइट टू एनैक्ट लॉज ऑन प्रिवेंटिव डिटेंशन. नेक्स्ट पैराग्राफ. इफ अ पर्सन इज केप्ट अंडर प्रिवेंटिव डिटेंशन, if a person is kept under preventive detention beyond a period of 3 months, it should be authorized by an advisory board comprising of a judge of the concerned high court, and two retired judges of high court as members. Clear? So this advisory board that is there, it will advise whether preventive detention should continue beyond a period of 3 months or not. इस advisory board का काम सिर्फ और सिर्फ हाँ या ना का होता है. It does not gives reasons for why it should or why it should not. No. The only job that it has to do is recommend whether preventive detention should continue beyond a period of 3 months or not. Clear? Next, this is where we complete our discussion on the second fundamental right, that is right to freedom. Third is right against exploitation. The third fundamental right is right against exploitation. Right against exploitation. First fundamental right under Article 23. It prohibits trafficking in human beings, trafficking in human beings, trafficking in human beings, comma, begar, and labor that is involuntary, next paragraph, right? Trafficking human beings means engaging in slavery and forcing people into immoral activities. Begar means involuntary labor with or without payment. Involuntary labor with or without payment. Example, bounded labor. The parliament has enacted Immoral Traffic Prohibition Act 1956, which prescribes punishment for engaging in immoral trafficking. Article 23 clause 2. The state can compel an individual to provide service. The state can compel an individual to provide service with or without payment, in public interest. ठीक है. Article 23 clause 2 is an exception to Article 23 clause 1. Basically, Article 23 clause 1 says what? Any form of human trafficking or involuntary labor, involuntary labor is prohibited. Involuntary labor with or without payment, very important, with or without payment. That means paying money is not the justification to force an individual to take up a particular act. ठीक है, paying money is not a justification. Otherwise, there are a lot of immoral activities that can be carried out. Like if we take an example of forcing someone to prostitution. Now, forcing someone in prostitution. Now, even if money is being paid, it does not mean it becomes legal or moral. So, when we say involuntary means with or without payment. However, the state can compel an individual to provide service provided it is in public interest. Now, interestingly, there have been many cases here, not that important in terms of for our examination purpose, but there have been some cases like in the state of Manipur. There is one of the tribes who has had a tradition which was more than 150 years old. What was the tradition? The tradition was that every household, one individual from that household every day is going to provide free service, free labor to the head of the tribe. This was a tradition that went on for more than 150 years. There were two individuals who challenged this in the court, that I am being forced to provide labor and I don't want to do that, but I am being forced to do that. Why? Because it is a tradition that has been going on. The Supreme Court declares it to be unconstitutional. The Supreme Court says only if you want you can. You cannot compel someone to provide service or any kind of labor. It will be what? Involuntary labor. However, the state can provide that. The state can compel you to provide involuntary labor, whether it is paid or unpaid. It may be paid, it may be not paid, but provided it is in public interest. Example, if you look at the Indian Police Act 1861, Indian Police Act 1861 authorizes that any individual who is above the inspector level, if he finds that there is a situation wherein the number of police personnel are outnumbered, he can force an individual without discrimination to provide services to the police. Jaise, if suppose there is a crowd, that is coming, and there are some individuals like 10-15 individuals which are, if they are gravely outnumbered, in that case, if there are some individuals who are passing by, they can be forced to if there is an individual who is an inspector, who is inspector level or above, he can force that individuals to provide service for the police. He can be forced. So it was challenged that this is also involuntary labor. The Supreme Court said no, it is in public interest, provided it is done without discrimination. Now you cannot say okay, ये गाड़ी वाले आ रहे हैं, they are in expensive car, so let them go. दूसरे वालों को पकड़ो. That is not to be done if it is without any discrimination. Similarly, there was a case in which in PDS system, public distribution system that is there. So in one of the districts, in one of the block level, what happened was there was a truck carrying food grains that was about to reach a particular place, and that had these food grains, and it was to be distributed to the people. But what happened was, because of the kind of road etc. that was there, it was not able to go beyond a particular point. So the district collector of that particular area ordered some individuals, police, to go to the village nearby and bring some individuals who are healthy enough to carry this to the godown. He forced the individual who went to the village, he forced some individuals to do that, and hence there was a case registered against that individual. It was questioned in the Supreme Court. Why? Because it was considered to be a violation of fundamental right under Article 23. You are taking up involuntary labor. I do not want to do that. The Supreme Court said no, it is in public interest. It is in public interest and the state can do that. It is justified. So suppose there is a natural disaster and you are a doctor, you can be forced to provide services. It may be paid or unpaid, it does not matter. You may be forced to provide services. Suppose you are an individual who is a owner of, suppose a shop, you can be forced to provide whatever you have as service to the citizens. The state may or may not pay for you, pay for whatever you do. Why? Because in public interest this is allowed. This can be done. Clear? Next, Article 24. Article 24. It prohibits employment of children below the age of 14 years below the age of 14 years in hazardous industries, the Child Labor Prohibition and Regulation Act, the Child Labor Prohibition and Regulation Act 1986 declared 14 industries as hazardous industries, and prohibits employment of children in such industries. For other industries, the Act regulates the employment of children. In 2011, the government prohibited employment of children in household activities, and dhabas. If you look at the current law strictly prohibits child labor. पहले इसे कहीं ना कहीं रेगुलेट भी किया जाता था, अब ये खत्म ही हो गया है. एक तरह से चाइल्ड लेबर पे कंप्लीट बैन है. So not just those 14 industries, but almost all industries. But if you look at the Constitution of India, says only hazardous industries, and that is the reason why in 2015 the government thought of amending the law, 1986 law, and the government wanted to prescribe that any individual who has a household business, so they can employ their own children. Okay, if they want, they can allow their own children to help in taking up such things, but provided they have enough time for leisure activities, because if you remember, right to leisure under Article 21. So if they have appropriate time for leisure, so they should be allowed. But this law was never passed because, obviously it started facing a lot of criticism that you are in a way allowing for child labor. As it is, despite the existence of the law, in India child labor is very prevalent. If you look at countries, you will find that there are certain countries like Africa, in certain continents like Africa and Latin America, some countries there, after that, if you look at the maximum number of child laborers, it is in India. So as it is, despite the law, child labor is so prevalent. If you amend the law and you allow for this, so it is going to create a loophole in the law, and so the government decided against it. Clear? With this, we complete our discussion on right against exploitation. There were only 2 articles, so we have completed the next fundamental right as well. So tomorrow when we meet, we start with right to freedom of religion. Thank you.